Any mention? His Lordship, I beg to mention item number 12. Correspondent 1 and 2, Lordship.
Yes.
Appearing for 2 weeks time.
You're appearing for the
Correspondent number 1 and 2.
so number
1 and 2.
1 and 2. The Union of India.
Yeah. On behalf of Mr.
They can
Dibnath.
mention on behalf of Dr. Majika
Mr. Dibnath, Lordship. Mr. Dibnath.
or Mr. Debnath. Yes.
No objection, Your Lordship.
Yes. It's paid for by so and so on behalf of Mr. R. Debnath, London CGC. This is better after 2 weeks.
2 weeks, Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 14 of the daily list. I have informed the other side there is some personal difficulty today. Subject to Your Lordship convenience, this matter may be taken up tomorrow.
14. Go to next.
14.
Who is the other side? Who is the other side, Mr.?
Other side is Mr. Sharma, M. Sharma.
Have you informed him?
I have informed him.
40. Yes. Wait for the land council of the petition. District week. Yes.
May I please, Your Lordship. Your Lordship, I beg to mention item number 15.
Yes.
Your Lordship, Madam N.G. Silla is the counsel for the respondent here. She is LEC. I'll inform her, Your Lordship.
You
I
are
was looking
responding.
for her. Your Lordship,
You are making a mention. We have
on
You are
the
responding.
petitioner, Your Lordship. I'm for the petitioner.
NG Sheila is appearing for the respondent, isn't it?
Yes, Lordship. I could not find her. I'll inform her, Your Lordship.
Your Lordship, she haven't come.
You have for?
I'm present for Ms. Inshallah, Your Lordship.
This is a
She's legally also, Your Lordship, in this
legal aid counsel. Okay, so you have no objection. This is a civil revision petition.
Lordship.
Yes. So you are making a mention on behalf of the petitioner.
Lordship.
When do you want it?
After 2 weeks, Lordship.
Same order. That's very common. At the request of the petitioner? Give your name. Yes.
Please, Your Lordship. Your Lordship, I'd like to mention item number 9, Your Lordship. If Your Lordship can have this matter after 3 weeks, Your Lordship.
You are appearing for the petitioner.
Petitioner, Your Lordship.
Lordship, appearing for respondents 1, 2, and 3, Lordship.
No objection.
No objection, Your Lordship.
Okay, yes, speak for by the Land Council. For the petitioner, list this matter after 2 weeks.
3 weeks, Your Lordship. 3 weeks.
3 weeks.
Right, Your Lordship.
May I please, Lordship? I beg to mention item number 13, Lordship.
13.
Yes, Lordship.
Yes.
May this matter take up after 2 weeks, Lordship.
Appellant. This is a criminal appeal.
Yes, Lordship.
You do not want to take up the matter. Accused is in the appellant is in custody.
Yes, Lordship.
For the prayer of the appellant. For the prayer made by the Land Council for the appellant. At the prayer made by the Land Council. This is matter. After 2 weeks. After 2 weeks.
Also, Lordship.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 17. Lordship, here I am entering evidence on behalf of the appellant, Lordship. So I pray for 1 week time, Lordship, to file my power.
You are entering appearance on behalf of the appellant.
Yes, Your Lordship.
What happened to the counsels who are already there? on record?
Because I got an instruction from the
That
client.
is all right, but then are they still on record, or are they have they withdrawn?
They have given the NOC and all, everything, Lordship, they have given.
You filed your power.
Lordship, I pray for 1 week time to file.
No, you first file your power and then you make a mention.
Alright, Lordship.
Since there exist some advocates on record,
Alright, Lordship.
or we can say that you have been
Yes, I have been. Yes, I got an instruction. To
Mr. Shula, you are there.
Yes, I'm there, Your Lordship.
Okay. Mr. S. Deb.
be there.
Be there. Be the learned counsel has submitted that he has been instructed by the appellant to appear in this matter. He has been instructed to appear in this matter on behalf of the appellant. Now the existing advocates on record will not be there anymore.
No, Lordship.
As the existing counsels will no longer be there, no longer be appearing on behalf of the appellant. Stop. The learned counsel 6 grant of some time for preparing himself. Prayer alert, list after.
Lordship, I pray for 1 week time, Lordship.
It will be 2 weeks, Your Lordship.
List after 2 weeks. Yes.
Apply, Your Lord.
Lord,
Prayed for by Mr. There.
Lord, item 6 and 7, my Lord, I have a prayer for mention by adjournment of this matter. Let me kindly have this matter after 2 weeks.
6. Item 6.
6 and 7.
No. Yes. Item 6 and 7. At the request made on the petitioner and not objected to by the learned counsel appearing to the respondent. This is matter after?
2 weeks, my Lord.
After 2 weeks. You are appearing for petitioner in both the
Yes,
matters?
my Lord.
Yes.
Sorry, in item number 7, I am for the respondent.
So this will be item 7, it will be respondent. Okay. The respondent not objected to by the petitioner. And the other thing is that petitioner. Okay.
Apply.
Yes.
May it please your lordship.
Yes.
Your lordship, I beg to mention item number 11. Your lordship, may this matter come after 2 weeks.
None but the respondent, Your Lordship. No objection. Just for the straightforward the learned counsel with the petition. This is matter after 2 weeks. Objection.
Supplementary cause list, item number 1.
May it please your lordship.
Yes.
Your lordship, I'm appearing on behalf of the counsel for the petitioners. Your lordship, can the matter come up at the end of the board? Your lordship, the conducting counsel is on like
Application for condemnation of delay, isn't it? Delay. Are you an advocate on record?
no, not in this matter, your lordship. I've just been asked to make a mention
Just wait. At the end of the board.
at the end of oblige, your lordship.
Daily cause list, item number 1.
Be pleased, my lord. My lord, pray for some time, my lord, today.
This is a matter. Is it related to that?
Executing matters, my lord, yes. Execution matters.
This is eviction
Yes.
in that building that.
Salon, yes, my lord.
Salon sir mentioned.
Yes,
It cannot be taken up by this.
my lord.
I think there is a
There's a revision
connected
which
criminal
allows us
matter
to
also.
appear,
Connected
yes.
criminal matter also.
Yes, my lord, yes.
FIR was filed. FIR was submitted, isn't it?
Yes,
And let it be listed before that.
my lord.
Because probably I had appeared.
Yes, you'll also appear on state.
There may be conflict of interest. And this is matter before any other bench without me. Then right bench.
All right, yes.
Item number 2.
May it please your lordship.
Yes.
Your lordship, I have already filed my affidavit of service of confirmation.
Whether the service, the service is affected.
Reflected, your lordship.
Nobody is appearing for the state.
Your lordship, I think Mr. Sengupta is on legs, your lordship.
Somebody should be there. There are many state councils.
I'm sorry, I inform you.
So nobody has entered appearance.
No, your lordship.
You have just submitted a tracking details.
Your Lordship, I have given the report also, Your Lordship, where it's shown that it's reflected.
Where is the report?
Lordship, that is at Annexure 2.
No, that is a tracking details. You see, madam, you have to obtain a certificate. Certificate is issued by the postal department. It is not signed by the postal department. It's the only tracking details which you have downloaded.
Your Lordship. Your Lordship, then I will make again.
Submitted by the Learned Council to the petitioner that an affidavit showing the factum of service of notice upon the respondent number 4 has been filed. However, the perusal of the affidavit shows that change has been filed on the basis of the tracking details of service and not on any certificate of service issued by the postal department. The Learned Counsel for the petitioner prays for grant of some time for obtaining necessary document and filing a proper affidavit. Prayer allowed when?
Your Lordship, 2 weeks, Your Lordship.
List after 2 weeks. Yes, Mr. Guru, after 2 weeks.
My lord.
List. Prayer allowed, list after 2 weeks.
Obliged, Your Lordship.
Item number 3.
Awaiting paper book.
Please, Your Lordship. Lordship, I have already filed my affidavit on the status of service for all the private respondents.
Have you enclosed a certificate of service?
Yes, Your Lordship. We have filed on 6th of this month, Your Lordship. For 6, 7, 8 and 9. And
Yes.
for 4 and 5 is 25/11 of 2024.
How many there are how many reports are there?
Six, Lordship.
Your Lordship.
6, 7, 8.
1, 2 and 3 state respondent and the rest is the
9,
private
Lordship.
respondent.
The private respondents are 6. All the respondents are 9, including the state.
Okay, there are 2 affidavits. One is
One is for 4 and 5, Your
4 and
Lordship,
5.
and the rest we did it dusty because some written
the rest you have served by Dusty.
dusty, yes, Lordship.
But then where is the report service? Where is the acknowledgement that they have received?
We have filed it. Lordship, we have annexed the dusty. The Lordship receipt is on the next page. Next page, signature and date is there, Your Lordship.
Yes. On the reverse.
Yes, Your Lordship. I pray Your Lordship, let the matter come for hearing.
Nobody has had an appearance.
No, Your Lordship.
Nobody's okay.
The other side may appear, Your Lordship, on the next date. Time may be given.
Definitely we'll do that. Yeah. However, just let us see. How many respondents are there?
9 respondents, Your Lordship. 1 to 3 state respondents and the rest are the private respondents.
So all have been served now.
All have been served, Your Lordship.
Yes. The land counsel for the petitioner service submits that yes, service affidavit. An affidavit showing the effect of service upon the respondent number 629 by Dusty Service has already been filed. And service in respect of all the respondent is complete. Mr. J. Thava, Learned Counsel, Learned GA appears for the respondent number 1, 2, 3. However, none appears for the respondent number 4, 229. Just wait for the parties. Is this matter for hearing after 2 weeks?
After 2 weeks, Your Lordship.
Yes.
And Your Lordship.
Unless, Your Lordship.
Item number 5.
There is a motion to approve this thing. The part one, are they ready? Lawyers are there. You see, after end of the board, ask for time. Is the lawyers are there? Yes, Mr. Nangpiu, you are ready for the motion? Yes. Just wait. We'll just have this. Give that.
Supplementary causes. This item number 8.
Application stands allowed. Yes.
Please, Lordship. This Lordship, as per the order dated 26/11/2024, Your Lordship, we have taken a step to 26/11/2024. Yes, as per the order
2021.
24.
What for you are referring?
No,
to?
Your Lordship, we have served a notice to the managing committee and the school managing committee. Actually, they have received a notice, but we are yet to file the affidavit of service, Lordship. Just to file the affidavit of service that they have received the notice actually, but they still
There
they
is
are
an amendment in the thing.
Yes, because they are the main respondent hearing. Because I was
Just
a teacher,
just a minute.
Lordship.
Go slow. This court will not understand anything.
Lordship.
Just tell us, was there an amendment in this amendment of this petition?
Yes. Amendment.
So thereafter, you filed a recast application.
Yes,
you filed in the amendment petition.
Yes, Lordship.
Amendment to what extent?
Amendment to extend that earlier occasion, Your Lordship, when the petition was filed. After the filing of the repetition, after some 6 months something, then they have come up with another notification, another impugn order.
Mr.
So,
wait just a minute. What is the amendment, Mr. K.P. Bhattacharya?
My lord, what had happened is that initially when the writ petition was filed, my lord, the petitioner did not enclose the order of dismissal, my lord. My lord, she was stopped from going for work, but there was no dismissal order.
So subsequently, the petition was amended.
So, my lord, what had happened at the final stage of hearing, my lord, we raised this objection that this petition is not maintainable and he should file a fresh writ petition, my lord. However, this honorable court, considering the matter, my lord, allowed him to file an amended writ petition.
Yes. Has he filed it?
I have filed.
Yes, amended writ petition has been filed.
Amended writ petition is filed, and that dismissal order has been incorporated.
Yes. Now.
Then what remains now?
Now, my lord, earlier what had happened, the managing committee Miss S. Bhattacharya was appearing in this matter, my lord. So, however, she recused herself from this matter. So thereafter, my lord, after amendment, my lord, on behalf of managing committee, no one has appeared. So, what my friend is telling is that he has served notice.
Once a person has knowledge of pendency of a case, just because the engaged counsel withdraws, do you have to send him fresh notice?
My lord, because what Ms. Bhattacharya told was that she is unable to contact the managing committee, my lord. That is the difficulty. So perhaps they are not aware.
She was engaged, isn't it? She was engaged.
She was engaged, but she is no longer in the
managing
case.
committee has the knowledge of that. Are they a very vital party, managing committee, or the state?
No, they are the main, my lord.
Yes, Mr. So
Yes.
what? This is pending for what now?
Now this is actually once the managing committee appear, then the hearing we can hear the
If they
matter.
do not appear, then
After amendment, my lord, it will also be necessary for for the state to give response, my lord.
If they wanted to file any objection,
was there any change in the government?
Yes,
there is no change. Only we have stated that we are not able to enclose at the time of filing of
Have
the.
you supplied them a copy of the
Yes, we have
amended
supplied a
petition?
copy. We have supplied a copy.
You have taken instruction. Do you need to file any?
I have sent for instructions, my lord. If necessary, we will have to file, my lord.
Yes, there is an earlier occasion by an order dated 25/7/2024.
My lord.
You were given chance to respond to the amended petition.
My lord.
Filed with the petition, isn't it? Then you have not filed any response.
We have not filed, my lord.
Yes.
Now, where is that order by which MS Bhattacharya withdrawn herself?
This one, this is 26/11/2024.
26?
26/11/2024. Of course, it is not mentioned. This for this indicate respondent according to.
There is no order on
No,
26/11/2024, Mr. Sangma.
11 to the order is not
Okay,
reflected
that is-
of her.
That is there, Mr. See, you do not prepare yourself. You do not bother to look at the record also. And just come and make submission the way you want.
No, Lordship, actually.
No, this is not the way, Mr. Counsel. You do not even know when the order was passed. Nothing. Yes, it appears that she has withdrawn herself. Acha, there is an order to issue fresh notice.
Yes, my lord.
And then?
Order 25/7.
See, it is pending for appearance of service report.
Yes.
The NEDI card has been received on 2011-2024. It is dimmed. Their service is dimmed. It seems lawyers hardly bother to read record and make submission. It is now pending for your response, if you at all, or response by the respondents, if you at all desire to.
My lord, I'll pray for some time, my lord.
Because service is complete, so there is no question.
I'll pray for some time, my lord.
The matter is pending for where is the order? Filing of response by the respondents against the amended petition filed with the petitioner. Mr. Eti Bhattacharjee, learned GA, appearing in view of the state respondent number 1 to 4. Praise for grant of some more time for obtaining a necessary instruction in this regard. Stop. None appears for the respondent number 5 and 6. Stop. As prayed for by the London State Council. Further 2 weeks. Well, is granted to obtain necessary instruction. To obtain instruction with regard to the response to be filed by the state. Lodge. Yes. To obtain necessary instruction with regard to the response to be filed by the state.
Item number 10.
Much first, Lordship.
May I please, Lordship? My Lord, I am for the petitioner in this writ petition, my Lord.
Yes, Mr.
My Lord, the petitioner was enrolled in the Assam Rifle as a rifleman, female GD, my Lord. On 13/2015 and discharged from service on medical ground, my Lord.
Yes.
And her prayer for the disability pension has been rejected, my Lord. So kindly
discharge from the service on medical ground.
Yes, my Lord.
Yes, she was rendered unfit.
Yes, my Lord.
Yes.
No, my Lord. During the training times, he was got some injury.
Yes.
And due to this injury, my Lord, she was discharged from service on medical ground.
Medical
so
ground.
Kindly,
yes.
Yes, my Lord. So kindly see, my Lord, page number 21, annexure 4, my Lord, of my writ petition.
Is it something like disability pension?
Yes, my lord.
Page 21.
21 annexure 4, my lord. This is the original copy.
Yes.
This 25 years old recruit of Assam Rifle Training Center and School reported to ARCH, my lord. This is the Assam Rifle Composite Hospital.
Just a minute. 20, page 21 is a medical.
Annexure 4, medical report, my lord.
Yes, and then it is handwritten.
My lord.
Yes.
Handwritten, my lord, and typed copy is page number 22, my lord.
Oh, yes, on the, yes.
So 20, I am reading from 22, my lord. This 25 years old recruit of Assam Rifle Training Center and School reported to Assam Rifle, this is the typic mistake, my lord, Assam Rifle Composite Hospital. With pain in the left hip joint following BPET. This is the part of the training, my lord, BPET.
Yes. Yes.
The pain is persistent 1 month, my lord.
Yes.
Now, my lord, come to page number 25, my lord.
Yes, just a minute.
Annexure 6.
Just a minute, just a minute.
My lord. My lord, my lord.
Page 26.
Page number 25, my lord, annexure 6.
Yes.
Para number 2, my lord.
Yes.
In there now, therefore, in exercise of the power conferred under the provision of contributory pension rule.
Just a minute, just a minute, just a minute. You are reading page 6.
25, my lord, 25, annexure 6.
Yes. Yes.
May I read, my lord?
Yes.
Paragraph number 2, my lord.
Yes.
In now, therefore, in exercise of power conferred under the provision of contributory pension rule 2004, within bracket introduction of new pension scheme to all central government employee, I do hereby give notice to so and so who shall be discharged from service on so and so on medical ground, my lord.
Yes.
As a disability case of old healed Pertha's disease with coxa magna left hip, my lord. Thereafter, my lord, kindly turn page number 26. This is the impugned discharge order, my lord. Annexure 7.
Yes.
Annexure 7, my lord, serial number 8, ground for discharge.
Yes.
On medical ground.
Yes.
Thereafter, my lord, several representation appeal has been filed by the petitioner and now come to the rejection order, my lord, page number 44, annexure 14.
Yes.
This is a letter of 8 November 2021, my lord. Paragraph number 2. On scrutiny of seat roll of your client number so and so, it is revealed that she was enrolled in Assam Rifles on 31st 3/15 and discharged from service on medical ground due to old healed Perthes disease with Coxa magna left hip with effect from 30/9/2016 after having rendered 1 year, 5 months and 29 days service. Now, paragraph number 3, my lord. It is intimated that in terms of para 3 of CCS extraordinary pension rule, this and this disablement should be attributable or aggravated by service condition with 1% and above disability for grant of disability pension. As per medical board proceeding, the disability of your client was neither attributable to nor aggravated by service condition with nil percentage of disablement. Hence, she is not entitled for the grant of disability pension.
Yes.
This is the rejection order. My humble prayer before your lordship, kindly see the affidavit in opposition, page number 18, my lord.
If a person doesn't have disability, it will be discharged from service, holding unfit to be retained.
But here what happened, madam? The petitioner.
What is the law? Just do not talk in reference with this. What is the law? When a person is given this thing, like when a person is retired due to health ground, when is given is discharged on the ground of disablement.
But there will be two categories, my lord. One is that somebody joins healthy, my lord. At the time of recruitment was medically fit, and subsequently during the course of service, my lord, suffers some kind of
medical
injury.
fitness during time of employment, that is presumed. You cannot say that you have taken into service an unfit person. Once a person goes through that medical test, that means he is fit.
Well, some diseases are not discoverable easily, my lord.
So how do you attribute it? If it is not discovered, then why do you have that system of test? It cannot be to that extent.
But that is the only issue.
Only thing is that when you hold somebody,
my lord,
see, unsuitable to be retained in service because of some medical reason, definitely person is rendered disabled. So how can you say like you do not, that person is not even having 1% disablement?
But here
what is meant by that?
But here the case is that she was suffering from old healed pulse disease with coxa magnata left hip, which was a childhood disease which mainly affects children.
Once you have taken somebody into service, I don't think you can take in this. Yes, Mr. Kumar, you were referring to para 18 of the affidavit in opposition.
Affidavit in opposition, my lord, kindly see page number 16, my lord.
Page number
This is the opinion of the specialist opinion, my lord.
There are many unnecessary litigations, Mr. Dr. Majika. I think, especially this, you see, like those by those army authorities, Assam Rifles and all. You see, like.
But here, what happened? She served only for about a year.
We'll come to you. We'll come to you. These are all initial reaction to the court. See, you can definitely change that by saying your version. Yes.
Page my lord, page number 16, my lord. This is the specialist opinion, my lord, of orthopedics from the army hospital, my lord.
Yes, their authority.
Yes, my lord. And in this specialist opinion, it is nothing to show that this disease is the childhood disease, my lord.
Just a minute. Wait. This is
page number 16, my lord.
This is annexure. Anything? Nothing.
Annexure, my lord. 2 R2.
Reverse side of the annexure R2.
Yes, my lord. And
R2 is the original copy. Then
yes,
reverse is the typed copy, isn't it?
Yes, my lord. Yes, my lord. That's why I am writing this, my lord. Yes. This in the specialist opinion, my lord. This 24 years old recruit, a case of old healed Perthes disease with coxa magna left hip, become symptomatic with pain left hip following a fall of during BPET, battle physical efficiency test, my lord. This is a part of the training, my lord. And in their opinion, they have nothing shows that this disease is the childhood disease.
What does it mean? What does it mean, sir?
BPET, my lord.
No, the entire. Just read it again. Just read it again.
This 25 years old female recruit, a case of old healed Pathas disease with Coxa magna, left him,
By
become
saying, see, old healed means what is meant by old healed? How old it is?
Old healed, my lord, she was injured.
No. If you say old healed, what did it mean?
Old healed, my lord, she was injured as per the annexure 20. Just a minute, my lord. Annexure 2 of my writ petition, my lord, the injury was sustained on 15/9/2015.
No, that is you are saying it. We are not saying it. See, does it refer to the injury which you have received during the time of?
Yes,
Or
during the
it
training.
would mean that some injury which was there before that. If you say we are just trying to get the meaning what is portrayed here. You see, the meaning which has been portrayed here, not what you say. Right now, we'll come to what you say.
My lord.
Here, if it says old healed, would it
My
mean
lord.
injury which you have received during the time of training?
During the training on 1st September 2015, my lord.
You are not getting the. Acha. Now, do you want to? I do not know. This is a language.
Now, my lord.
Okay. 1st September 2015.
Yes, my lord. Now come to the last line, my lord, please.
Yes.
Last line, my lord. Recommended to be invalidated out of recruitment training in LMC low medical category, that is A5, my lord.
Yes.
So due to this low medical category, I was discharged from service, and their opinion, medical opinion, my lord, that is.
Where is your discharge thing? Just you. Oh, this is in okay. Okay, in your writ petition.
My lord.
No, yeah. Now, what is LMC A5?
LMC means my low medical category,
Yes,
my lord.
that is okay. A5 means A is. Where is where is that medical categorization rule?
Medical categorization rule, my lord, I have not annexed it in my writ petition.
No, but then we must see.
My lord.
What LMC A5 means.
A5 means completely unfit for further training or further service.
That is what we want to see this. There are many things, Dr. Mojika, isn't it?
5 categories.
Yes, my lord.
5 categories.
A1, A2, A3.
A refers to what? A is
A
what?
record for shape and fit, my lord. A is record for fit.
Wait. Not A. A refers to what? S1, A1. What is A? What is S?
I'm not carrying the.
No. You just have to give it that this court would not understand.
When the matter comes up tomorrow, I'll come up with this. Those medical categorization rules.
You do not want to disturb this for this.
For a moment, my lord, if allow me, kindly see page number 19, my lord, of affidavit in opposition. Yes. This is the opinion of the medical board, my lord.
Page 19 of the
affidavit in opposition, my lord.
Yes.
This is the opinion of the medical board, my lord, which was conducted by the respondent authority, my lord.
Yes, it's on the top it is written, yes.
And kindly see column 1, para number 1, column 1, my lord. Does the disabilities exist before entering service? No.
No, that is all right, but then that is what is provided here also. Even at page 16 also.
My lord.
You have read out just now before that.
My lord.
There also it says that he following a fall during PPT, isn't it?
My lord.
So that means this entire injury has arisen on 1st September 2015 after you had a fall.
My lord. My lord.
So at the
My
time
lord.
you were in service.
My lord.
Yes. All right, then.
Then, my lord, they are saying that this is a childhood disease. That's why I am referring this, my lord. And my lord, see if my affidavit
What
is
you are
replied.
claiming in the writ petition? What you are claiming in the writ petition? What is your claim in the writ petition?
My claim is that my prayer portion is, my lord, at
What you are claiming?
my prayer portion is page number 13 of the writ petition, my lord.
Yeah, what is it?
To set aside and cause the impugned order dated 8 November
What is that
2021.
order?
That is
Where is that order dated 8 November 2021? The
that is
reply to your legal notice, which you have.
yes, my lord. Yes, page number 44 annexure 14.
Yes,
That is
8
the
December 2021.
rejection order, my lord. And second one
Release
is
the pension. Release the pension. What pension you are claiming? There are many
disability
kind of
pension.
pension. What pension you
Disabled.
are? As according to
That,
you
my
are
lord.
entitled to what pension?
Disability pension, my lord.
Disability pension.
Yes, my lord. I have written in the
Where is
second
that?
prayer portion.
Where is that law which makes you entitled for disability pension?
Can I read, my lord, the second portion of my prayer, my lord?
No. Where is the law which allows you in such a situation to claim for disability pension? Your case is that you have
My
been
case,
released from service because
yes,
of
my
an
lord.
injury which you have received during the course of service. So
My
once
lord.
you rendered disabled during the course of service, you should be given a disability pension, isn't it? Now, where
My
is
lord.
that law? Where is that law?
So,
This court doesn't know anything. You have to show
my lord,
the basics.
I am praying that to direct the respondent to constitute a medical board of the petitioner by fixing a percentage of disability and to release all the pensionary benefits as receivable by the petitioner.
Yes, Mr. Dr. Majika, that's appears to be a quite fair thing. You constitute a board to determine the disability.
In fact, the other day, also disposed of one matter, madam, in similar lines.
Yes.
Same
So let the petitioner appear before you, isn't it?
But today I'm not carrying that. Lots of matter comes up tomorrow. I'll place that the previous order.
Yes, Mr. Kumar.
Similar lines.
I think that will be wise if you direct the respondent to
My
assess your disability,
my lord,
and to pass a necessary order,
my lord,
depending on the disability, as to your
my
entitlement
lord,
of pension.
my lord. It can be, my lord. To reassess the, it can be,
So that will be all right for you.
my lord.
And when the petitioner will have to appear on certain date for when the authorities notify to make
My
it
lord.
appear before the medical authority. So you have to
My lord.
there.
My lord, my lord.
Where do you stay? Where do you stay? Where the petitioner stays?
Manipur, my lord.
Yes. So she'll have to give she'll have to be given prior notice.
My lord.
So we'll do that, Dr. Mojika.
That order I'm not.
If you do not have any serious problem with that, because once you render a person medically unfit,
It appears that
there has to be some sort of disablement.
Physical training, she suffered some injury, and that aggravated her old disease. So she had some childhood disease, my lord, but that was aggravated because of fall during the training.
That is aggravated.
That is aggravated.
But then the thing is that your medical board says that there was no disability existing prior to her joining. Your own report says, your own affidavit says.
Of course, because there are some decisions which say that there is a presumption if somebody was recruited in armed forces after extensive physical.
If your medical board categorically rules out existence of any pre-existing disease, where is the question of drawing presumption?
But in affidavit we have said that she had old Higgle percentages.
You say it, but then you see
That is in the
your
medical report also.
reports, all those things. It says only this thing. This has happened following that BPET on 1st September 2015.
That's true, my lord. But the report also says that she had this old childhood disease, my lord. Page 20. it
That
says.
is on what basis you say it? You may say it, but then there is no basis.
In my submission, my lord, I think the same order should follow in this also. So, appear for determination of percentage of disability, my lord.
See, don't you think that in this kind of cases some cost should be given to the petitioner, because repeatedly we are having this kind of cases?
As if there are very few cases, my lord.
See, because do not know, because we have seen the many matters involving
Disability, I
us,
think
especially you see like those kind of things, like the people are you are basically forcing the people to come and approach this court, incurring considerable medical expenditures. These are see, sometimes you take some stand in your affidavit which goes against your own document.
Well, the other matter, lordships, in the petitioner approaches after 45 years, my lord.
There was the order passed by
now for
coordinate
department
bench
also to accept a claim after
the bench of
45
justice,
years, my
thank you, also had passed this kind of order. See, so there are
My
many
lord,
matters.
my lord, I'll just read the rules, my lord. The governing rules, my lord. It says, my lord, no award shall be made in respect of an injury sustained more than 5 years before the date of application. Death which occurred more than 7 years. So there's a time bar under the act also that you cannot come up. I'm talking about the other case, my lord, where the petitioner came after 45 years, my lord.
We will dispose of this matter. We'll direct the petitioner to appear before this court. Heard Mr. V. Kumar.
V. Kumar, sir.
Allied counsel appearing for the petitioner. And also Dr. N. Majika under DSGA appearing for all the respondents.
All this.
Appearing for the respondents. Sometimes your valuable advice works, Dr. Majika. Unnecessary dragging people to litigation.
Well, my lord, even this claim also, my lord, 16 injury, my lord. As per the rules, there is a limitation of 5 years.
Limitation of
5 years.
5 years. But then on the other day, Mr. Jha was pointing out to some rules with regard to the claim of.
So 3 years, that has been decided in Tarsem Singh's case with Supreme Court. If somebody approaches court very late, my lord, the areas will be payable only for the period of 3 years from the date of filing of the writ petition.
Anyway, just that paragraph. The petitioner was enrolled in the Assam Rifles as rifleman within bracket general duty, female, on 30/9/2016.
I'm sorry, my lord, this is a typical mistake, my lord. This is 31/3/2015. In synopsis, only in synopsis, there is some mistake, my lord, typical mistake, my
See,
lord.
whenever we try to shorten our time, it becomes longer. What is the date? You said 31st March.
31st March 2015, my lord.
Now you said she had a fall on.
In September 15.
Anyway, she one is on so okay. Stop. It is a case of the petitioner that during the final test of military basic training, on 15/9/2015, during B, capital B, capital P, capital E, capital T, just within bracket you write battle physical efficiency test. Battle physical efficiency test. She suffered an injury on her left hip. Subsequently on medical categorization, she was held unfit to be retained in service and was discharged from service on medical ground by the respondent's authority. The petitioner grievance before this court that in spite of she being discharged from service on material ground, no pension, no benefit of pension was extended to her by the respondents as per her entitlement. Stop. Paragraph. The learned counsel for the petitioner, drawing reference to the various amendments made in the petition and to the various documents annexed with the petition as well as the affidavit of opposition has submitted, that it's a clear case where the petitioner has suffered injury during her service tenure and because of that she was recommended to be invalidated out of recruitment, invalidated out of service. Is that correct? What is it? Yes. Yeah. Because of the last thing, because of that, she is yes, recommended out of service. Yes. The learned counsel drawing attention of this court to the opinion of the medical board of the respondent authority dated, what is the date of that? What is the date of that?
19 April 2016, my lord.
Why do we get it?
19 April 2016.
Where do we get
Page number 16, my lord, of affidavit in opposition.
Page
Top,
number
my lord, top of the page, summary and opinion of Lieutenant Colonel so and so.
Okay, 19th April 2016, dated. Has
My lord.
submitted that the medical board has categorically opined that there was no disability. There was no existing disability with the petitioner before entering service. He therefore submits that the petitioner is therefore entitled to disability pension, and the respondent authority is bound to assess percentage of disability in order to extend the benefit of pension to the petitioner. Stop. Paragraph. Dr. Majika, not a DSG, appealing for the respondent, on the other hand, counters the submission made by the learned counsel for the petitioner. Countering the submission advanced by the learned counsel for the petitioner. It say countering the contention raised by the learned counsel for the petitioner, submits that the petitioner was suffering from some pre-existing childhood disease which got aggravated at the time when she was sent for training. He further service that there is no available data showing the percentage of.
Just interrupt one. The page 20 of my affidavit, there is a finding that there is a nil disability. Page 20 of my affidavit.
20 of your affidavit. Yes.
It's serial number 4, madam.
Yes.
There's a table. It's a disability as numbered in question as part 2, old health plus disease so and so. Percentage of disablement is nil. Probable duration of this degree of disablement lifelong. Composite assessment or liability is nil.
So what does it mean then?
It means that as such,
if that percentage of disablement is nil, then what is the probation duration of this degree of disablement? Is it not contradictory?
Well, it is not contradictory. What it says, my lord, I'll just point out. There's a finding that because of this disease, he will not be able to perform at page 19, my lord. The previous page, the last sentence I also say.
Yes.
Page 19, the last sentence. In view of the long-term treatment and regular follow-up for the disease, she is unfit for active military service.
So what are the kind of pension you have? One is disability pension and other is
Others invalid pension. That requires 10 years of service.
Invalid pension will not come here.
Will not come.
So she only her claim can at the best considered for disability pension. Nothing.
Disability pension, as I pointed out on the earlier occasion also. Earlier there was a view that 60% minimum disability is required for getting this. Now that has been clarified that it can be proportionate. Even if the disability is 20% or 10%.
Where is our termination order? The thing got disrupted now. Will not be able to continue with the
Termination order is page number 26, my lord.
of your writ
Of
petition.
Yes, my lord, annexure 7.
Just a minute. Now, what comes under disability? That is the main thing. Grounds of discharge is
On medical ground.
So it doesn't say about disability, isn't it?
It doesn't say.
So now, if you say that medical ground, then we have to see that that medical categorization rules. Without that, we cannot decide anything. Okay, well, how a person can be, whether a person with similar kind of like difficulty can be categorized under A5 or not, and if a person is discharged on the ground of A5, then what are the liabilities of the department? That has to be seen. So it is not that we can send it back only for disablement, because this is not a discharge on disability. But the other day, what we disposed of, that was because you granted him invalid pension or disabled.
He brought a certificate from some civil hospital, my lord.
Yes,
determining his
that is
disability.
where the
50%.
department wanted him to submit a certificate, and which he did.
My lord.
And then you see, like before that, he was discharged on disability. He was discharged on disability ground. It was specific. Here it is not.
It is not.
There is a difference. Now, Mr. Kumar, you see,
My lord.
If you are not disputing that F5 categorization, then we have to see what benefit you are entitled to. Because in a writ jurisdiction, it will not be possible for us to overcome the finding of the medical board. One thing we are very much clear, that what medical condition she has,
My lord.
that thing has arisen during the course of service. So this court has confusion with regard to that. But then we are a bit confused with regard to your entitlement.
Entitlement on disability pension, my lord.
Yes, whether medical categorization, medical A5 can be categorized as disablement, and you will be entitled to get disability pension or not. That is what we must know.
So, my lord, my prayer then, my lord, please fix the matter on 18, my lord. I will be physical on that day, my lord. I will place the medical categorization act on that day, my lord.
After doing all these things.
Otherwise, my lord, I agree with your lordship. Please re-examine my medical disablement, and then after.
So we'll do one thing.
My lord.
We'll tell them re-examine and determine your medical condition, and if you suffer from any disability, then to assess your representation.
My lord.
Normally, the finding is already there is a zero disability. Only thing is that
when A5 can come, on what situation a person can be discharged under A5. Now that is what we have to see the rule.
And what is the consequence of that?
Only we can see that much.
What will be the consequence of that?
That is what. And then what is the consequence? That is what. Because otherwise we have limited jurisdiction.
Fixes the matter. I'll call
Just cancel that entire part. Just say you can preserve it somewhere later on. We may require it anyway. Not require it. Just say after arguing the matter at some length, the learned counsel for the petitioner prays for grant of further time, grant of some more time for further preparation in the matter. Prayer allowed? List on? Is there problem?
18,
No.
18, my lord.
List on. 18th.
My lord. Deeply, your lordship.
Item number 16.
This matter had been fixed, Your Lordship, on the prayer of the petitioners to produce some land documents after it was heard at length, Your Lordship. This, if Your Lordship goes to the order dated 15th July.
15th July?
Yes, Your Lordship.
Last year, 2024?
24.
It was heard?
It was heard.
At that point of time?
Yes, at some
It was heard on the 4th of July, Your Lordship, at length. Heard on 4th of July at length. Then thereafter, the petitioner sought to bring in some documents.
certified copies from the
GHS.
district council, from the, then till date we are waiting for that. Your Lordship.
Now, the objection was filed by the respondent number 2 in the month of June. That's a requisite document from the Garo itself. Okay. Now, have you obtained those documents?
Lordship, we have tried, but we were informed that Jamabandi is the only record available with them, and they have further informed the Jamabandi is the authenticated record, and therefore whatever the papers are available, I will argue on that.
What we are dealing with in this matter?
There is a this is a petition under section 482 for quashing the FIR and
There's
the
an FIR against you.
FIR
involving line thing.
Yes.
It's okay then.
Yes, Lordship.
So no document is this thing.
So, Your Lordship,
No.
in that case, if my friend doesn't submit any documents, Your Lordship, then the matter may be taken up on the next stage, Your Lordship, because I have not come prepared. And there were some
Fair.
other files also.
Very fair. Then you should have informed her.
No, I was informed in the morning.
Oh, in the morning, Your Lordship, just when we were sitting before in this court.
In that case, allow me to finish my second report.
No. That we do not want to do. Please.
And we've been accommodating them for all these
Basically,
days.
No, I'm not objecting. I'm not objecting.
Accommodating them for the last 7-8 months.
Just a minute. Yes.
And Your Lordship, I also have a prayer. There are 2 other criminal petitions which were, where the 2 accused persons were also officials of the district council and who have also, and they were arrested on the basis of the same FIR, Your Lordship. And they have also come before this court, Your Lordship, for quashing of that FIR. So if the matter can be heard together, I think that would...
Whether all those matters can be disposed of by one judgment. They may have different grounds.
Yeah, different
grounds are more or less the same.
No.
Because
let us first proceed with one
Okay,
matter. We'll see. If it covers up, then other works.
Yes, then others can.
Well, just Mr. Vicky Jindal, London Senior Counsel.
Lordship, can we fix it on 17th
of
this month?
17th, I think, is a Sunday, isn't it?
No, Monday.
After 2 weeks, Your Lordship, it's too short.
Next week not possible. Mr. We'll have it after 2 weeks. You will wait over this next. Mr. Vicky Jindal, London Senior Counsel. Appearing for the petitioner submits that this matter was pending or enabling the petitioner to obtain some documents from the Garul Zarnoon District Council which might have been relevant for the purpose of the adjudication of this matter. However, today on instruction, the learned senior counsel submits that there exists no other document in the records of the Garul Chattanooga District Council apart from what apart from which finds place in the writ petition.
Pardon, sir?
Apart from which are already appended with it.
And by the opposite part, and by the respondents, Your Lordship. We have also filed some documents.
Apart from which are already there in the records.
In the records. That.
Apart from which. In view of the submission. If any of the parties submit that matter can be taken up for final hearing. Stuff as prayed for by the parties. Is this matter after 2 weeks?
Your Lordship, I'm appearing for a private respondent.
Yes, that will go automatically, Mr. Bucks. That will be recorded.
Deeply appreciated.
No.